Domain name dispute. Well, the first thing I've got to say is, please don't avoid domain name disputes. Because I'm a domain name lawyer, and I make my money out of domain name disputes. So my background is in DRS's, the .uk domain name dispute. I've done, I think, 9 DRS appeals. I can't remember how many actual cases, but 9 appeals is 3 or 4 times as many as anyone else. I've also done a lot of UDRPs for .coms and other extensions, AUDRPs for the Australian domain name dispute process, and a few High Court cases thrown in just for good fun. So, you know, if you avoid domain name disputes, I'm going to starve. Now, Peter Coleman last night said that might not be a bad thing, and my kids would probably agree with him, but so yeah, maybe yes. How do we guarantee a way of avoiding domain name disputes? I have the answer. And the answer is, don't own any domain names. Because that's the only way you can guarantee to avoid a domain name dispute. I have represented people in what you might consider to be utterly crazy disputes about totally harmless domains, and no matter how clean your portfolio is, people can still come after domains with totally spurious complaints. So the only way to avoid domain name disputes is to not have any domain names. And I'm assuming that's not an option for most people in this room. So then the next best thing you can do is review your portfolio. Because even if you have harmless and valuable domains, if you also have domains that are questionable, you can guarantee that the lawyers on the other side will collate your dubious domains and put them into the complaint saying, well, look, they've got all these shady domains, this is one of them, even if it isn't.
Do you think they should review them alone or with an attorney?
What a great question. And after talking to various people last night in various stages of inebriation in the bar at the excellent party after yesterday's event, I would definitely advise people, I'm not going to name any names as to people who told me, oh, I've got these domains and they're perfectly safe. Please have somebody else, another domain professional, a friend or whoever, even if you don't pay for a lawyer, please have somebody else sanity check your portfolio, because what you may think, I'm not going to name any names, they're not in the room anyway, but it is much better to get a second or third opinion to make sure that your portfolio is clean and if necessary, split the portfolio or do something with it so that it's kept elsewhere. I mean, of course, there is a different business model where you are intentionally keeping domains that are connected to corporations and things with goodwill, and your objective is to monetize them and then dispose of them. That's a different, but I'm assuming here we're talking about domain portfolios that have capital value, and that is your purpose of keeping the domains. So check your domain portfolio. Yes, of course, use a lawyer because we're cheap and cheerful. But you know, use the resources in this great summit. People that you've met, you know, sign an NDA or whatever if you need to, and then get somebody else to have a look at it. And if necessary, dispose of the ones that might give you trouble, even for your good ones. I mean, in the DRS, for example, if you have 3 adverse decisions in a 2-year window, the balance and burden of proof shifts from the complainant to the defendant. So that's a very bad thing if you've got a large portfolio, and the type of people who are acting for complainants are aware of that sort of thing and will then target you. So do avoid it.
Jim, do you mind if I ask a couple questions as you go?
No, keep going.
Could you give a very ballpark figure of what it would cost to have an attorney review maybe either an existing portfolio or a portfolio that someone is looking to acquire? Do you think most people in the audience already know about what that cost is, or they're used to, maybe if they're used to just having a few friends review it, they haven't really thought the cost to benefit ratio?
Well, certainly it's a very good point, because if you are actually looking to sell your portfolio or buy a portfolio, Des, you just missed the bit about you. He's just come into the room. We were just talking about sanity checking portfolios. Yeah. If you're doing it formally, then obviously it's a cost of the transaction, and you factor it in. And I mean, you can go to a big law firm, and it'll be, if they're doing the whole deal, and then obviously they're, as everyone knows, very inexpensive. Or if you are doing it as you go along, then a specialist domain name lawyer would probably do it for a fixed fee, and it would really depend on the size of the portfolio and also the difficulty of the advice. I mean, the more domains that you have that are questionable, then the more thought would have to go into advising on whether to keep them or dump them. So I'm afraid I can't give you a number, but it's a good idea. So I'm just looking at my notes to prove that I had prepared this talk. So in the end, there's no certainty, if you have a portfolio, that you will be able to avoid a domain name dispute. In which case, I'll highlight a couple of the basic differences between the different dispute processes. I'm not going to talk about court litigation or anything like that. I'm going to talk about UDRP, DRS, and AUDRP and things like that. The UDRP is bad faith registration and bad faith use. So the complainant has to prove both of those two things in order to win a UDRP. There was, for a while, an attempt by one or two, shall I call them rogue panelists? Yeah, I'll call them rogue panelists. One of them's actually, I think, a professor of intellectual property law at Melbourne University, a guy called Andrew Christie. Give him a name check, he deserves it. Who tried to effectively rewrite the policy on the hoof so that they tried to rationalise that the word "and" really meant "or." Go figure, it doesn't. And that was resisted. So now you do definitely have to show both registration and use being bad faith. And that makes it harder for a complainant compared to the DRS policy here for .uk, where it is abusive registration or abusive use. And one of the things that I would say is, if you're talking about avoiding a dispute, particularly in the UK, or any of the other policies that are OR, parking becomes a big issue. Because if you're parking your domains and that is considered to be use, and if that use then relates to the complainant with the goodwill, whereas if you'd registered it in good faith in a .com and then used it and the parking might give rise to a complaint, it can't succeed, because if you can show that the registration was in good faith, you're okay. That doesn't work with .uk. So, for example, there was an appeal case for oasis.co.uk, and it was an interesting case for a number of reasons, not least of which that a response wasn't put in time, so that it was lost on default before I was asked to do the appeal, which does make it a lot trickier. But we were able to establish that the complainant had deliberately manufactured the results of the parking that they were using to succeed in their complaint in order to generate the screenshots, in order to then make it look like the registrant was taking unfair advantage of their goodwill. But that clearly required quite a bit of research and some technical evidence that had to be put into the case. So, but if you are parking and not managing the parking, you are held to be responsible for the way that the parking works. And another case that related to parking and use was the MySpace case, where the domain had been registered and parked before. I mean, we're going back in time so that MySpace doesn't really exist anymore, but back in the day, it was a very big social network. And the parking results changed because MySpace became so successful. And so the question then was, is the registrant at fault for basically sitting there and getting the benefit of that? And at first instance, they lost, but we won it on appeal because we were able to, so in the UK, if you can show you haven't changed your use when you're parking, and it simply is a result of the sudden fame of whoever the third party is, then you do have a defence. But in general terms, particularly with .uk's, my advice would be think very, very hard about parking if the domain has a good capital value. Because is the parking revenue worth the risk of losing the domain? Now, one other very handy defence, and I stress it has to be genuine and plausible, is if you didn't have prior knowledge of the complainant when you were registering the domain name. We have in the room with us today Michael Toth, the legendary domainer, and Michael was the registrant of verbatim.co.uk, which came under threat from the people who produced the sort of CD-ROMs and memory sticks and things of that name. And the primary defence in that case was that Michael hadn't heard of them. And the question was that plausible or not? The panel on the appeal determined that it was, and it set a fairly high bar for the type of brand recognition that you would have to have, because clearly that's quite a big business. I think from memory it was part of Mitsubishi or Samsung or someone at the time, but the brand itself was pretty well known. But that set a very high bar, or the panel set a reasonably high bar for where you'd have to establish a presumption that the registrant was aware of the domain of the complainant or the complainant's rights at the time of registration, and that if you didn't establish that, and there was a clear statement from the registrant that they didn't know about the complainant, then that was largely a sort of end of the dispute and successful defence. But I repeat, that has to be plausible and genuine, not something that you can run either with a massive household brand or where the complainant can establish that you had direct knowledge of them in advance. And we've sort of, another case of Michael's, I'm not suggesting Michael's involved in a lot of disputes, but another, but by pure chance, another case where Michael was the registrant, which was slightly more of a finesse, if you like, of the verbatim defence, was when in the Lalique case, and in that case, the honest statement of defence that Michael made was he'd heard of Lalique as in antique glassware, but he was unaware that there was a company still manufacturing glassware using the name Lalique. And so he was unaware of the complainant whilst he was aware of the antique and collectible glass. And that was a successful defence as well. So Michael is now the expert in Lalique glassware, amongst many of his talents.
And was that a .com or a .co.uk?
So that was a .co.uk again. So both of those, it was a question of the same idea would work in .com in terms of registration, but there are more pitfalls in .uk because of the risk of, if you establish abusive use only in .uk, that's sufficient rather than abusive registration and abusive use, which you have in .com. one example where that happened, for example, I'm speaking from memory, but I'm pretty sure this is how it fell, was the champagne.co.uk case where the registration was not abusive, but for a brief period of time they'd been selling, I can't remember whether they'd linked to an off license or something like that, and so Champagne were able to show a period of abusive use. It wasn't even ongoing at the time of the complaint, but that was enough to win the case, which wouldn't have worked with a .com because if you couldn't show an abusive, and there is a difference in terminology, bad faith and abusive, but if you hadn't been able to show bad faith registration in the case of a .com, that would be enough. You have to show both in .com, you have to show either or in .uk. And that's a very significant distinction and why I'd say you'd have to be much more careful with things like parking and where you choose to point your domains in .uk. So I'm aware that we're drifting sort of towards lunchtime, and far be it for me to keep the crowd away from lunch. So rather than rabbit on a bit more, now I'd like to open it to questions, if anyone has any questions, not hopefully specific ones about a particular domain. Hello, Rex. Back from Malaysia. Just to ask me a question.
Could you give a bit more information about the UDRP process and the proving of bad faith registration? Because who has to prove that? Who has to show that it was? Is it the complainant has to show it? So you can just say it was not a bad faith registration, that's your defence, and they have to prove otherwise? Or do you have to somehow prove that it wasn't?
Very good question, Rex. The burden of proof, in the way that the policy is written, sits on the complainant. In reality, that's not necessarily always quite how it works, because it's not exactly unknown for panelists to draw their own inferences. But some gunshot or something there. But in principle, it's for the complainant to prove. However, if your defence, I'm going to pick a random and ridiculous domain, but let's say you had Coca-Cola.com and your defence was you'd never heard of Coca-Cola, then you're going to struggle to persuade a panellist that that defence is legitimate. But again, one of the bits of advice that I would give to avoid an Andrew Christie type panellist in the UDRP, particularly if you've got a valuable domain, you have an option. There's no appeal process in the UDRP, whereas there is in the DRS. So at first instance, you have an option to choose 3 panelists rather than 1. You do have to pay a fee for that as a respondent, but if you've got a valuable domain name, in order to ensure proper dialogue and proper recollection, for example, of the burden of proof, far better to choose a 3-member panel than risk a randomly appointed single member who then can do whatever they like. And like I say, you don't have a right of appeal other than to the courts. Appealing to the courts in the UK, how can I put this? It's an open and complicated question. In the US, there is a route to the court that's in statute, but there isn't anything equivalent to that here. I've been in cases here and in Australia where we were taking a UDRP to the courts in Australia, which settled in the week before trial, so we didn't actually get the final determination on whether or not you could do that there. So get a 3-member panel in UDRP to make sure you get things like the right application of burden of proof. In the UK, you can't choose a 3-member panel in the first instance, but you do have the internal second-tier appeal in the DRS, where 3 members sit. So I suppose the short answer is, in theory, it's down to the complainant. In practice, the panel will take a view if your position is almost untenable. It'll be then on you. The other thing, of course, is if you have 3 adverse decisions in the DRS within a 2-year window, that burden of proof does officially change so that you have the burden of proof as the registrant rather than the complainant. So again, another reason to review your portfolio. And if you get a complaint where you really don't have a serious defence, don't take it through to a decision would be my advice, even though I might otherwise be representing you and making a few quid. But my advice would be to offer them the domain and get rid of it rather than end up getting an adverse decision which will then be used against you.
So Jim, if you have 2 decisions that are adverse in a 3-year period?
3 decisions in a 2-year period.
Okay, then is that like a speeding ticket that it kind of expires once those 3 years are up? Or is that like that will follow you 10 years later, they'll still say you had this black mark of this time frame?
Bit of both. Officially, it's a moving window, and if you've got the 3 decisions within the 2-year window, then you have the official switch of the burden of proof and the presumption effectively almost of guilt. In practical terms, even if you only have 1 adverse decision, it's all, I mean, if I have clients who maybe have 1 adverse decision, many of which go back many years, you can rest assured that the complainant will refer to that and then try and establish that there's some sort of pattern of abusive registration or bad faith registration, as it would be in the UDRP. So if you've got a hopeless case, drop it. It's just not worth it.
Do we have further questions?
Let's see if this works.
Hi, Richard. Really interesting presentation. I was wondering, you were talking about reviewing the portfolio. To which brand database do I need to review it?
Well, I suppose the first point is if you have, if you have a domain and you haven't, it's almost better in some ways not to, you're not obliged to go and check the trademark registry or something like that. It's more a case of, have I got something here and actually I automatically know it's company X? Because if you don't know that, genuinely, I'm not encouraging anyone to, let me go on record, I'm not encouraging anyone to lie in their representations. There's a statement of truth in these documents, and it should be taken seriously. But let's say you don't know or weren't aware of company X or brand X, that is a legitimate defence. So I suppose to a point, doing too much research in order to then inform yourself of a potential complainant, unless you're planning, and of course it is explicitly legitimate to, if you have a generic domain name or portfolio of domains, that's explicitly a legitimate business practice under the DRS. It's actually in the policy. If you find 10 people or companies that might have value in your domains and you approach them all, you haven't registered with one of them in particular in mind. But it's more of a, does it pass the, I mean, this isn't formal legal advice, but does it pass the sniff test? Did I genuinely just register this domain name because it came up at auction and it had a high SEO ranking or whatever? I wasn't actually, it wasn't Coca-Cola.com. I didn't know, I wasn't thinking of any particular complainant. If it's a 3-letter, say, or 4-letter acronym, it could have any number of potential registrants, and it's not, let's say, picking one at random, IBM, so you automatically think of one potential user. Everyone knows that 3 or 4-letter acronyms are often popular with many businesses. That's perfectly legitimate. And then you may well do your own research in order to establish who might be interested in buying the domains, but as long as that wasn't in that none of them were in your mind when you registered it, there's your defense. But if you do have registrations where the potential complainant is very obvious, then my advice would be to either get rid of those or do something so that they're not, that your sort of less difficult domains don't get caught up in and be associated with them.
When you mentioned that before and now, kind of splitting a portfolio if there are some with higher risk, would the purpose of that really be to have it under a different entity name so that any black marks were only on that side? Or would the purpose of that be to avoid losing the larger portfolio from some type of damages?
Well, I mean, it would be a question of how effective that would be, because it might itself look like underhand conduct. But if you do genuinely dispose of a number of names by cleaning a portfolio, perhaps finding a buyer who's willing to take them on, and you've got rid of them, then they're no longer on your portfolio, then your high-value generics that shouldn't be might attract interest, might attract a dispute. As I say, the only way to avoid a dispute is to not have any domains. So you might have perfectly legitimate domains that attract, nevertheless, complaints from brand owners who have an interest in them and don't want to buy them from you. So what you don't want is those caught up with something questionable, and they will list them, or if you have adverse decisions in particular, they'll list those and they'll try and establish that you are someone of bad character and the panelists shouldn't believe a word you say. And then you've got a more difficult job in persuading the panel that you aren't such a dubious character.
Do we have any more questions? Thank you so much,
I think
Jim.
it's lunchtime.
Yes.